Welcome back to Good Morning Tobago, and thank you so much for staying with us. We begin conversations this morning by speaking with Mr. Mac James, former Labour Secretary, and we're talking about the situation, as you are aware, that's in the public space. It's been in the media, in the news, and of course, we all have our own opinions. But we're going to have the conversation this morning as it relates to the Tobago House of Assembly now facing the Industrial Court and being told that they have to pay $3 million to 13 employees whose contracts were terminated. Good morning, Mr. James, and welcome.
Good morning to you, Ms. Combie.
Right, a pleasure having you in studio this morning. Now, it's no secret. The information is out there, and this has happened. We know that 13 employees were sent home. We want to get the details in terms of, because I want to go through the entire process. I don't just want to start at the fact that the THA has to pay $3 million, right? I want to go through the process in terms of how the contracts were terminated, how the unit was scrapped, whatever happened there in that arrangement that caused 13 employees to be out of a job and leading to where we are now. So let's go through the phases. How did we get here?
Well, okay, let me see if I can detail the history of the matter. So when the TPP administration under Mr. Augustine came into office, I think sometime in 2021, am I correct? Well, of course, every administration has a right to do what it thinks it should do in respect of its policies, in respect of its mandate, and to find the best way forward in managing its units and divisions under its control, and to determine at what speed it should do so and how it should do so. So you don't fault an administration for doing that. All administrations have done that. PNM did that as well, even as early as when in 2001, when Mr. Orville London became the Chief Secretary. So there's a history of administrations taking such actions as it deemed fit in respect or in pursuance of their mandate. So it's nothing new. What the court is interested in is the how and the process, whether procedurally or substantively. And I'll break down those terms for you in a while. All right. Recently, when the PNM came into power, sometime in 2010 or thereabouts, the Ministry of Tobago Development was scrapped. There have been several employees over the course of the different administrations where the employees have always won the THA. The unions have always won their cases. And it appears to me, as an industrial relations person, as a former trade union officer, and in many respects I still am, the administrations don't learn.
And I was just about, what you're saying, it really leads to that, because if you're saying each time this action is taken, and rightfully so, they have, the leeway to do, you bring in, you ensure that your mandate is established, your policies, whatever. But if this happens every single time, is it not something that needs to be assessed and approached to be taken differently?
Yes, there's a significant problem within the political class in Tobago in particular. And the Prime Minister had to comment on a larger issue now, where lawyers are being paid substantial sums of money. Matters have to go to court, and workers take long to get a solution to the matter. Mm-hmm. And it puts them at a significant disadvantage. In the particular case, where 13 workers were dismissed or sent home, whichever term you want to use, retrenched, the court considered the matter and ruled in favor of the workers. The judgment being delivered, the Chief Secretary, I heard, decided that he is going to appeal. I'm not here to support any party, whether the Chief Secretary or the workers. But it appears from the ruling of the court and from the evidence that was tendered, evidence that was pleaded, that the workers had a case, and the court ruled in favor of the workers. Now, my thing is that you met the workers there. It's their bread and butter. You may have political differences, but there's a pathway, a very narrow pathway, which you must follow if you want to change the workers. You don't like them, or you feel this unit in particular, you don't need it. That's the work. That's the employer's right. So as I began, I'm restating what the court is interested in is the pathway that you take in proceeding with your mandate or your policy, or to achieve your policy ends. It appears from the evidence pleaded that the chief administrator at the time, Mr. Edwin John, would not have, in the opinion of the court, conducted the necessary consultations. And the court, from the evidence pleaded, determinations were handled in a very abrupt way. Another issue is the question of compensation. Now, there was a significant unused part of the contract of the workers, and therefore the court felt that if you're going to make the situation whole again, you needed to compensate those workers who did not complete their contract of employment. Some people had contracts about 3 years, and there was an unused part for about 9 months, some 10 months, some a year. There were different periods where the contracts were not completed. In the opinion of the court, the workers' situation should be made whole. It can't be that you are appealing a matter and yet you don't, and you say, listen, your contract, we are not going to renew your contract. So if you're not going to renew your contract, then why not pay people to the end of their contract? It is your right not to renew the contract. You might in fact be wrong based on the whole question of legitimate expectations, and in this case they close down the entire unit. But so if you're not going to allow persons to continue on a next contract, then you have a duty to compensate them for unused part of their contract. It just makes sense.
Mr. James, I know that you are well educated in this topic. One thing that I was wondering, right? What are some of the things that caused the administration, and when I say the administration, I mean the Tobago House of Assembly, to drop the ball in terms of how this was handled, how this was managed? Because you're saying, okay, this is where we are now. You close down the units, and you're saying that they must compensate their workers. But before we even get to that, when we're talking about closing down the unit, from the reports, it states that they were in the process of restructuring, and none of these things seem to have happened in the period.
So,
right.
So if you're going to restructure, the first thing that has to happen is a directive from the Executive Council. The Executive Council has to meet, a minute has to be provided, a note has to be provided, which ends up being a minute or an instruction or an authority to do these sets of things. If that doesn't occur, then there's no proper legal basis under which a particular secretary, whoever it is, could have been me, could act. It appears that was not done. Then before you could retrench, there are certain steps that must be taken. So you had to get a minute. It's not stated in the law, but that is the authority because you're in the public service, right? So you have to get a minute. Then you have to give notice. If there's a union, you have to notify the union, 45 days notice. Then you have to enter into consultations with the union/workers. If there's no trade union in place, then all the workers have to be consulted. Then you have to look at alternatives to separation. The court is a court of common sense, a court of social justice. The court looks at those things because the court will consider persons who have been working for so long. They would have entered into loan agreements, there have been financial commitments here and there. And for you, after so long, these people have been in employment for about more than 10 years in some cases. All right? And then it would appear to the court that something is wrong. Now, if you were saying you had consultations, where are those minutes? If you're saying that you are restructuring, where's the organizational chart? All right? There must be some evidence. There was no evidence in respect of those steps. Nobody was notified properly. You call them in, you have a little conversation, they issued a letter, they sent home. And that is egregious. And the court is saying, they said, no, that can't happen. But the court did not order reinstatement. It would not, under it, only on very special circumstances, might order reinstatement. So the court took a very narrow pathway, that is to say, we won't order reinstatement, but you must compensate. So the question arises, on what grounds are you really going to appeal?
I was just about to ask, the grounds to appeal it here.
We will come to that. And but there are certain social and socio-political considerations. These are people. The question of the political affiliation and allegiances and so forth would arise. And the court is saying, no, you can't do that. And time after time after time, all the administrations are making that same mistake. The PNM made that mistake for about 16 years, or maybe 20 years. And the TPP also made the same mistake. The court is not going to question your right to separate. It will question the process. And they always lose on the process because people are bloodthirsty. I don't want them people, listen, PNM do the same thing and they lick up our people, we go lick up their people. Those are the things that are said privately, but not openly. And the court will get on that, get beneath that to correct that wrong. And the ILO convention says, listen, workers have to be protected in spite of their political affiliation.
And I want to talk about the politics of the thing, right? And I know there's something called political science, of which I have no background. I'm not a professional. I'm not an expert. But is it not, political science, would it not say, let's study things, let us come up with a strategy for things. Yes, this is what we want to do. As you said, separation is, is acceptable, but the approach, how are we going to do this? We have seen so many administrations fail at this and having to pay, they got burnt by this because of the approach. Yes, I want a change because I am now the administration. And so this is my policy, this is my mandate, and this is how I want to do things. But how to do we do the politicians study the how-to part of it, or is it that they just immediacy? I want to get it done now by any means necessary. Is that how do you apply the political science in that to ensure that the how-to is done to perfection?
Well, I wouldn't say that's a question of political science. It's a question of governance, right? It's a question of corporate governance. Of course, it is flavored with some politics, not necessarily political science. Politics has to do with the systems,
tell you I'm not expert,
and ideology and so forth. And there's some administration involved in it,
right.
All right? But it's a question of governance. The module will be under the scope of corporate governance. For all wants and purposes, the administration is a corporate body, and therefore it applies. How you do it is the issue. Now, so you have persons who will advise the chief secretary, and I don't blame him too much, but I think he's wrongly advised and continues to accept worthless opinions. Some people who are about him, including some secretaries, who have their biases or their political biases. They have to be careful. Tobago is a small society. Where are you going to run to go? People are going to find you out. So that when you take bad advice, that's the issue. When you take advice that is loaded with spite and vindictiveness, that's the issue. So the question is, some lawyer or some untrained industrial relations officer will say, yes, you can do it. And they cook up a story, not understanding the whole question of human resource management in the context of industrial relations. It's a whole separate issue and body of information and so on that you must bring together to determine the best way forward. You have to be well schooled in industrial relations. When should I do it? How should I? Is the industrial act been followed? Is the collective agreement, for if that one exists, Has it been followed? So when you take advice from lawyers who only want money in their pocket, you will get that kind of advice. And then people are afraid to tell the chief secretary, no, sir, don't do that. Because one of the important things for the court in terms of the pathway towards separation, were there alternatives? Could these people have been placed elsewhere? And if you dig deep in terms of the human resource management of the assembly, I would say unabashedly that yes, you could have found some form of employment for them elsewhere. There are many divisions, but it's a reluctance to hire people that you believe to be P&M or TPP. Both sides have done it. So we have to go back to have some sanity in our industrial relations practice in Tobago. And the court would have ruled, look, you must compensate them. Might be to the tune of $3.5 million. And there are different awards for the different persons who separated.
And you know the question of the grounds for appeal, we're going to deal with that when we come back from the break. We have to go for a short break, ladies and gentlemen, as you are aware, we have bills to pay. And so we do hope that you could stay with us. When we return, we continue the conversation this morning. Be a part of the conversation. Remember, you can leave your comments on our Facebook and YouTube live streams so that we know that you're a part of what is happening here this morning. In the meantime, take in these announcements and we'll be right back after the break. Welcome back to GMT and thank you so much for staying with us. We continue conversations this morning with Mr. Max James. He is a former Labour Secretary of the Tobago House of Assembly and the holder of an MBA in HR Management. As you are aware, we are talking about the situation that the Tobago House of Assembly now faces with having to pay out $3 million to 13 workers whose contracts were terminated before completion. Before we went to the break, we were kind of breaking down where we are, how we got here, and the things that transpired that brought us to this position now. And I know you want to share some information in terms of what the court said, because now we're getting into, does the administration now have grounds for appealing? But before we get there, let's hear what the court is saying.
Well, on paragraph 70 of the judgment, it says, in considering appropriate compensation to the workers, for the workers, the court takes into account their manner of dismissal. All right? Which was sudden and in which they were not provided with the opportunity for consultation or to explore alternative employment. I discussed that before. In circumstances where that were akin to retrenchment, no payment was made for their past service or for loss of office. Further, there was no credible evidence that they were paid for outstanding vacation leave. So the court finds it fair and just to award the workers for their outstanding vacation leave and payment for the remainder of their period of respective contracts. The court also finds it just to order the payment of prorated gratuity for the period served under their respective contracts existing at the time of the employment, at the time the employment was terminated. The court, and this is important, the court finds this payment to the workers or for the time worked since gratuity is usually paid upon the satisfactory completion of employment. The payment of gratuity is to be based on their basic rate of pay unless their contracts provided for the inclusion of allowances in the computation of the gratuity. So what all this is saying here is that, look, the people had outstanding gratuity, normally paid at the end of the contracts, but there was an unused part of their contracts. The court is saying in terms of their discretion, and you can't out the discretion of the court. You can't appeal the discretion of the court. You can appeal if when I go through the grounds of appeal, if there's overreach or degree to which you do something. So the court will entertain degree and in terms of how the court might have ruled. That's the appeal court will entertain appeal on whether the court exceeded its jurisdiction or the degree to what it entered or did something. So the court is saying here, you have to prorate the gratuity for the time that they worked. Isn't that fair? I mean, the test of things are, if you go down the road and you ask 10 persons, the court or the law says, if you ask 10 persons, that's reasonable. we're not operating as a jury here, but any person, reasonable person, will say, but if the person worked for a period of time and you have no fault with their performance, satisfactory performance, that is, if their performance had been satisfactory, but you didn't do the performance appraisal or the performance management aspect of the employment, so the court found that not to be so. So what the employer has to do is to pay for it, because you didn't conduct an appraisal. There's no proper performance management system in place, so you have no legs to stand on. No, you could only appeal. You can't appeal on question of fact, because those are facts. And if you did not raise anything during the proceedings as to the jurisdiction of the court, then you can't appeal. So let's go to the...
Before you go there, I want to stay on the gratuity part a little bit, right? Because they can argue that, yes, the contract was not completed, and the fact that gratuity is paid upon successful completion. I really want to cover all the bases. I want to ensure that we understand where we are. Is it possible for the appraisal to be done retroactively now that we're in this position?
Well, the court has already ruled and made an award.
Right.
So that is of little consequence. It doesn't arise again. The matter is done. They're separated. So we can't, if they were to perhaps be reemployed, continue from the date that they were dismissed. So there's no air between that. And you may wish to consider that and to make it whole from that period up until now, perhaps. But the assembly doesn't have the proper functioning performance management system. Everybody knows that. And that is at the basis of their problems, because the court will look at the relationship, how we operated, how we did, how we related whilst I was in your employment or during the course of my employment with you. The court is big on process. And you can't just, you are government, you're an organization. So things have to be organized. Things have to be done properly. And there are rules in the workplace that govern the terms and conditions of employment. There are rules that govern performance, principles that govern performance. And the court says you must abide by those kinds of things. You can't breach. There's a duty of care. There's a duty for the employer to act in good fidelity. All right? So the court will consider those things, how quickly you did things. So the retrenchment issue, or the separation, not really retrenchment, but the separation issue, if you're talking about restructuring, you can't delete it at the end. So you have to delete it at the beginning. And there are no executive council minutes. There's no evidence of a organizational chart. There's no evidence that the workers were consulted in respect of who will go where, if they're going to keep them on, and where can we find alternative employment within the assembly. The court is a court of social justice, primarily. And it must be unjust to send home 13 persons without giving them a right to be heard. All right? So that's the substantive issue. It's a question of natural justice. Did I get a right to be heard? That's the procedural aspect. Was I given 45 days notice? That's the procedural aspect. The substantive issue is a question of fairness. Did the employer act fairly? And the court found them. I know of either one of them, the assembly's case would have been thrown out. So did the assembly act procedurally correct? No. No case for them. Did they act substantively fair? No. No case for them. So what are you going to appeal on? This is what the law says. The law says that, well, you can only appoint an appeal on perhaps three very narrow points or areas. On a point of law, whether the judgment was obtained by fraud, or whether the court did not have jurisdiction or exceeded its jurisdiction in the matter. Of course, the judgment wasn't obtained by fraud, so you have to X that out. Did the court exceed or didn't have jurisdiction? They all found to be workers, and the court is established to deal with disputes that involve workers, so its jurisdiction is in place. So the chief secretary can't appeal on that ground or the other ground. What are the points of law? I'm hard pressed to find any point of law because that is not the case, because it acted wrongly procedurally and it acted wrongly substantively. So there's absolutely no ground for the chief secretary to appeal except the fancy lawyer or the former minister of justice now working elsewhere in the assembly and other places, where she might tell him, yeah, because she claims to be a litigator. And I hope that he takes the advice that I've offered this morning and earlier in this week on another station. It comes now to the whole question of social justice. And I will say to the chief secretary, let me go down to the colloquial, oh God, chief secretary, please do the right thing. These people are mothers. Don't let the tears of the widows, who are, some of them are involved in this matter, fall upon you. These are people who, some of them, I know, based on their evidence, who turned around and voted for you and your party. The political capital that you have can be quickly evaporated because there are other matters coming up quickly during the remaining portion of this year. And it's the same issue that concerns the workers of TATCO, who were dismissed even after they were asked, do you want to continue your career? There are no executive council minutes that give that instruction. You have a board and a secretary doing what they think they should do. And then you are now going to distress the workers further by appealing. What are you doing to do? I in my little business, me and a rich person, I had to employ one of the ladies that 4 children. Social justice requires the chief secretary to make it whole for the workers. I'm asking the chief secretary in that other matter to withdraw the matter.
Let me ask this,
because the
Mr. James.
OWTU is a very powerful union.
Let me ask this question, right? In terms of...
And let me just finish the sentence. The OWT is a very powerful union. They are well versed in industrial relations. And the assembly, based on all the case precedents, they are on the verge of losing that matter. It comes up in August. And I'm saying we don't need to have further disruption in the society. We need to do it right for our people. The board was wrong in that case. We're not going to try the matter, but the secretary was wrong in that case, and people are suffering. The chief secretary said before he came into office that a worker should not have to fight for something he or she is entitled to. On the larger level, we have a right, may not be a fundamental right, some cases it is in some jurisdictions, a right to work and decent work. And you have to be careful when you decide to separate workers. It should be the last choice. That's what the court says.
I want to ask this question, Mr. James. I want to go back to the appeal. If the chief secretary or the administration decides that they are going to appeal the current case that we're talking about, what is it going to cost the taxpayers? What is it going to cost the assembly to appeal the case?
Well, I don't know what the lawyers are going to charge.
No, not in terms of the, the figure. What is it going to cost in terms of resources? Is it going to deplete the resources? Is there going to be a charge? Is there going to be a cost attached to it?
Well, the only cost is what he's going to pay.
Just the legal fees.
The legal cost,
okay.
The legal fees. And the longer it takes, the court might, if the union applies or makes amends or asks the court in terms of the compensation, might say, might be forced. Might or may be forced to order exemplary or punitive damages or add interest to it. But the court may not want to go there because it can raise a legal point in terms of punitive and exemplary damages. But it does so in extreme cases. So if you appeal, it's a danger, and the court may or may not decide to go that far. However, I think the cost to the assembly will be a political cost, because if you multiply 80 by, let's say, 3 dependents and friends added to that, you have to remember the figures coming down in the national elections just weeks ago. There are some seats that indicate that certain assemblymen can be in trouble. No, there may be things that can happen between now and then that might put them in a better place. We don't know politics. We just don't know. We didn't even realize that the configuration, we thought it might have been a 2-seat or 3-seat majority. It happened to be much more than that, and gave the UNC a 3/5 majority in respect of their ability to pass certain pieces of legislation. So you're not sure. But even if you're not sure, you have a duty to protect, uphold the law and the Constitution. And I'm saying again, if you look at the statistics over the years, since the inception of the court, the lawyers have lost multitudes of cases, multifarious now in terms of description, cases, all through the life of the industrial court. Because they like money, and the politicians like to listen to lawyers. They are no good in terms of industrial relations. They'll lose the cases. But more than that, the workers are your fellow sisters and brothers and citizens of Tobago. You have a duty to protect their rights. Why are you appealing a court decision that says compensate them to the end of their contract? This is a simple thing. Why are you going to appeal something that will deprive or delay workers the little payment, the little kakadan, so they could live? I mean, you're only taking them back, but they have Tobagonians too. There's no basis for the appeal socially or legally.
And it really is a situation that we were hoping we would not be in again. It's something that we see happening time and time again, and we're really hoping that this kind of action can change. But in closing, we spoke about a lot this morning, and there's a lot more that we can still unpack on this topic. But in closing, what are the key takeaways that you want our viewers to go away with, both the Tobago public and the administration, where this matter is concerned?
Well, firstly, you have a right to your political affiliation and must be respected. And you must not be abused because of your political. We have to end that polemic, that fight and quarrel in our Tobago space, as we like to say. And we must respect people because, in spite of their political affiliation. The next takeaway is that please don't delay the payment to the workers. Let us have trained personnel in industrial relations conducting our industrial relations business wherever it has to be conducted. Let us hire proper lawyers who are trained and schooled in industrial relations. The assembly needs to understand that. Let us not act on spite and vindictiveness and recrimination. It has no place, or to have no place in our society. So I think that we shouldn't appeal for appealing's sake to save face. It might be a face-saving measure of the Chief Secretary. I hope it is not. Let us be humble. Let us act with humility. And the Chief Secretary is a man of God. He needs to say, listen, I was wrong, or I was wrongly advised. I believe he was more wrongly advised, and he took that advice. The lawyers are out there they set like Mapipi, as we see, to make $1 here. And then they will give the Chief Secretary bad advice, or give him advice that is it sounds so reasonable that he might fall for it. So he needs all the assemblymen, PNM, TPP, industrial relations is not high priority. The Labor Department, I don't know who even is the secretary. You look around, I told Mr. London that when he came to office in 2021. When you lump labor and you lump it low down, people hardly hear it.
2001.
Huh?
2001.
2001, yes, sorry. I beg your pardon. So the idea is that labor must be given the priority and the status and stature that it deserves. It must be a forefront department or division. So you don't put, say, community development, so and then labor. And you hardly hear of the Labor Department. So we need to function in that way. You will look around the world. Labor is a standalone department or division or ministry throughout the world. It's only Little Tobago I see that. Look across the waters. You don't hear of and so and then labor. There's a labor minister, because it has to do with labor economics, it has to do with productivity, it has to do with industrial relations and all those social issues that pertain to work. So it must be, even if labor is not listed as a matter under the 5th schedule, it needs to be lifted out. In our time, I was the secretary for labor because we understood the importance of having labor as a division put in the right place so we can instruct the rest of the society in terms of labor economics, labor matters, labor economics, social justice, and all of that. So it must be a forefront division. So we need to reconfigure how we see labor. People see it, well, the workers are terrible. Well, we know some of them are terrible. I've experienced some of them, all right? But it speaks to your human resource management, isn't it? Your public administration must be a forefront division. It speaks to productivity and fairness and procedure and all those kind of things, and appointments and job security, if you could say that, and so forth. Getting your divisions functioning optimally. So is yet another opportunity to set it right in terms of the distribution of portfolios and the naming of portfolios in the Tobago House of Assembly. Labor must be a forefront, perhaps standalone division. It is a sorry state that we don't want to hear, we don't want to listen, and we're going to do it our own way, but maybe we might see the effects of that. It is not helpful. And to the people who are widows, who are fatherless, who are affected by this judgment, people who have bank loans to pay, car loans to pay, send their children to school. You met the people there, and there could have been some humanness, some humanity, if you wish, in your decision making. And I suggested to the Chief Secretary, there's yet time to make it whole and to make it right. I hope you will take the advice.
Thank you so much, Mr. James, for coming on this morning and, of course, giving us that insight into the situation and, of course, the call for us to do things better, you know, especially socially here in Trinidad and Tobago, and more so in the Tobago space where we are kind of community and family based here in Tobago. And so I do hope that, you know, we can make some advancements, some progress where this type of situation is concerned.
The people have a right to what the court has ordered as compensation. Let us do the right thing.
That's right. Ladies and gentlemen, we've been speaking with Mr. Max James, former Labour Secretary of the Tobago House of Assembly and the holder of an MBA in Human Resource Management. As you are aware, the Tobago House of Assembly currently faces a court order to pay $3 million to 13 THA workers who have been, their contracts have been terminated abruptly, and now they are being made to pay, of course, with the Chief Secretary stating that he is going to appeal the case. Let's see how that goes. Remember to stay tuned. You can leave your comments on our Facebook and our YouTube live stream. And of course, we always want to hear from you. We want you to be a part of the conversation. So always log into Tobago Updates Television and let us know what your thoughts are. This is where GMT ends for the morning, but of course you can join us later this evening at 6:30 p.m. for our evening news. I am Adanna Combie. Do have a wonderful day.